So mutual rights of the partners. Now mutual means amongst themselves. Mutual means amongst themselves. So what are the rights of the partners amongst themselves, vis-a-vis each other, against each other? Can you tell me what should be the rights of a partner? Just try to think in your mind. I'll give you a minute or two. You can pause the video here and just try to think in your mind what can be the rights of the partners amongst themselves. If you want, you can note the rights. And this is very easy. So pause the video here and then play it once you are done. Okay? Now this is the most important line, subject to the agreement. Now whatever rights are given, these are only, they serve only as examples. They are not inclusive. They are not exhaustive. They are not exemplary, but they are just for, serving as examples. They are illustrative in nature. Okay, it is nowhere written that these necessarily have to be the rights. If the partners decide amongst themselves, they can do away with that right. And this is the reason why we have written subject to agreement here. Now this depends upon the partners, because partnership, we said, the base of the partnership is agreement. It comes into existence with the help of agreement or contract. So it is dependent upon the parties mutually as to what rights they want to set for themselves. Agreement may lay down 3 or 4 rights which are not in this list. At the same time, the agreement may lay down rights, which are there in the list, but possibly they are not in the list, or the partners have specifically said that these rights are not available to them. So that all depends upon the agreement. Okay, so subject to agreements, we have the following rights. First, right to take part in conducting business. This is one of the most basic things that a partner has to do. He has done partnership to do business, so he has the right to do business. He has the right to take part in the day-to-day activities, in the day-to-day operations. Okay, now again, this is subject to the agreement. If one partner has agreed and the others also have agreed that he should not take part in the business, he should be a sleeping partner, then he does not have a right. Okay, but if there's no such agreement, all partners have the right to take part in the business. And if they are stopped, the partner can sue the other partners. The partner can sue the firm. He can take them to court. He can also dissolve the firm by giving notice. If he wants, he can retire, or he may also dissolve the firm. So such grave are the consequences if this right is not given to the partner, because this is the very basic right. He wanted to do business, that is the reason why he got into partnership. Now if that very basic, elementary and the fundamental right is not given to him, he possibly has no use being in the partnership. So he might as well retire, or he might as well dissolve the firm. That depends upon him. Second, right to be consulted. Now he is a partner of the firm. That means he is the owner of the firm. He is a joint owner or co-owner of the firm. So don't you think whatever decisions are taken, the owner should be consulted? Correct? The owner should be consulted. So if somebody takes a decision on his own, some partner takes a decision on his own, does not consult the other partners, will it be right? No, that will not be right, because the other partners are joint owners like he is. So they have a right to be consulted. So they have a right to be consulted. So likewise, all the partners have this right. All the partners need to be consulted before taking important decisions. Okay, but is it possible that for all the decisions, every time all the partners be consulted? No, it is not always possible. Now, some partners may be out of town or not reachable. They may be at some vacation or for some business purpose, or you know, every time it may not be possible. In such times, it's okay. The second thing is, when partners are consulted, it is not important that it is not necessary. It is not always possible that all the partners may always give the unanimous answers. They may answer unanimously, be it in the affirmative or in the negative. Some partners may say a yes to a decision, others may say no. So, what do we do in such situations? In such situations, we apply the majority rule. We go with the majority. Okay. Now, but there are some important decisions, like here the example is given. Change the line of the business, change the nature of the business. Now let's deal in some other product. Now this is a very big decision. In this case, the consent of all the partners will be required. You cannot go with majority rule in this. Otherwise, what will happen is, partners who are not giving their consent may move out of the firm. So only those partners who were agreeable may continue. So this can be one possibility. So this may lead to reconstitution or dissolution of the firm. So all the major decisions, all the partners have to be consulted, and every partner's decision is to be given equal importance. However, if there are some very petty decisions that need to be taken, not that grave decisions, in that case, if it is not possible to consult all the partners, it is okay. At least you should have the majority with you. Next, right to access the books. Now this is very simple. It's owner's business, so he has the right to check as to how the financial performance has been in the current year. How is it vis-a-vis last year's figure or past year's figure? What are the current year sales, what are the what is current year profit, how has the rate changed. He also has the right to inspect them, not only access but to inspect them. He may see if any mistakes are done in the books or any frauds are conducted, frauds are done. So he can check those things also, because he is the owner. He has the right over his books. Okay, so no one can take this right away from him. The important condition is, when he checks the books, when he inspects the books, it should be bona fide. Now what does bona fide mean? Bona fide means in good faith. So bona fide means in good faith. Okay. So he has to check the books in good faith. He just can't keep suspicion over all the other partners and keep checking the books daily. Though he has the right to check the books daily, but again that has to be bona fide. He can't be a source of unnecessary trouble for the whole of the firm. So, though he has the right to access and check the books, but that has to be bona fide. Access means gain entry in simple English, or gain hold of. You either gain entry or you gain hold of. Next, right to remuneration. Now, what is right to remuneration? Remuneration means something that you get in return, like a salary or commission or profit, or something of that sort. Now, partners are the owners of the firm, they are the owners of the business, so they should get the profit. But here, by remuneration, we mean salary. Do the partners have any right to get salary from them? Because they are the owners. Can an owner draw salary? Does he have the right to draw salary from his business? A sole proprietor probably does not have the right, but a partner surely has this right. The only condition is it should be written in the agreement. It should be written in the agreement. Otherwise, normally, if you ask me, a partner does not have the right to take salary from the business. Now, as I told you, it is very simple to understand that what a owner takes from a business is profits. He does not have any right to take salary, because salary is drawn or taken by the employees. He is not the employee, but again it is his business. So if all the partners agree, then they have a right to draw the salary. But if you normally ask me, they do not have the right to draw salary until and unless expressed in the partnership deed. Next, right to share profit. Partners have the right to share, because this is what they are forming the partnership for. The ultimate objective of partnership is profit. Now, the profit is earned by the firm, so it is to the owners of the firm. Now, owners are partners, so partners get to share the profit. Whatever the profit is, they distribute it amongst themselves. This is one of the basic rights of partners. Now the question arises, what should be the ratio of distribution of profit? So the answer is, the ratio has to be decided by them. The ratio has to be discussed and agreed amongst themselves as to which partner will get how much percentage. And the second question is, let's say the partnership deed or the agreement is silent. There is nothing written in regards to profit sharing ratio in the agreement. Now what do we do? Now the answer is, you have to distribute it equally amongst all the partners. So if the ratio is written in the agreement, it is defined in the agreement, you go by it. If it is not defined, you distribute it equally amongst all partners. Many people argue as to profit sharing ratio should be based on the capital employed in the firm. Now, the Partnership Act doesn't agree with it because the capital employed in the firm may, keep on changing depending on, the withdrawals, the interest, the salary, the profit. Each partner's capital may keep changing every year. So every year the ratio will change. That is not advisable. You know, Even what happens is in many cases the partners have two types of capital. One is fixed capital, the other is current capital. Now, if the partners decide that the ratio has to be as per the fixed capital, then it is okay. But if the partnership deed is silent, you cannot go by capital ratio. You have to distribute it equally. So many people think that if the partnership deed is silent, we'll distribute the profits as per the capital ratio. No, you have to distribute it equally amongst all the partners if the partnership deed is silent. Next, interest on capital. Now, normally, interest on capital should not be taken by the partners. It should not be given to the partners. It is not the right of the partners, at the onset. However, as I said, partners are the owners. So they may, if they are okay with an interest on capital employed by partners, all of them agree on this. It is this right is there in the partnership deed, then they may distribute the interest on capital. Okay. Interest on advances. Now, what are these advances? Advances means loans to firms. Loans to firms given by the partners. It's not firms, it's firm. Okay. So loans to firm. So if any partner gives any loan to the firm, he may recover an interest on it. Now this is a loan. This is not the capital. So he is giving it as loan, not as capital. So if he is giving loan, he has the right to collect interest, but it should be maximum 6% per annum. Now what happens is many times, a partner has left the firm, he has retired, but his capital is there in the firm. So he may treat that capital as loan to the firm and collect interest. What happens is many times the firm has dissolved, but the accounts have not been settled. So again, the partners have the right to treat their capital as loan and collect the interest from the firm. The next right is right to be indemnified. Now, what do you mean by indemnified? We've done this earlier also. Indemnified means to make the loss good. To make the loss good or to compensate for loss. Whatever the loss has happened, you make it good or you compensate for it. Now, on account of the firm, if the partner incurs any loss, then it is his right to get indemnified from the other partners or to get indemnified from the firm. Now, to explain this, I'll give you one example. There's a firm with three partners, X, Y, and Z. Now, what has happened is, there has been a court order against them that they have to pay, a sum of 1 lakh rupees to A. And if they do not pay, the court shall give a winding up order, a dissolution order. Now, to protect the firm, X by himself paid it to A so that the firm is not dissolved. Now, what do you think? Can X here recover the amount from the firm? Does he have the right to get indemnified? Does he have the right to get compensated? Because the amount that he has paid was actually the liability of the firm, but he has taken up on himself so as to protect the firm from dissolution. So don't you think he should recover this amount from the firm, because it was firm's liability? The court order was against the firm and not against X personally. So here X gets the right to be indemnified. Now he gets the right to collect 1 lakh from the firm or from the other partners. Now we can't say 1 lakh because X also has to contribute himself. So the remaining parts, 2/3 part, he has to collect from the other partner. So he gets the right to be indemnified. Okay, so if the partners incur losses on behalf of the firm to protect the firm in good faith, then they get the right to be indemnified. Now, the important condition is to protect the firm, or how a prudent man means a man with ordinary judgment, a normal, rational man, how he would have acted if the partner has acted that way to protect the firm. He gets the right to be indemnified. Next, right to stop the admission of a new partner. Every partner has the right to stop the admission of a new partner. Now you have to understand that partners are the owners. They are the owners of the business. Okay, now since they are the owners, they get to decide who gets the admission as a partner in the firm and who doesn't. Because partnership is based on faith and trust. So if partners do not have trust amongst themselves, or they think if a new person who's coming in is not trustworthy, they might stop his admission. They might say, I'm not comfortable with that partner, with that person, so I cannot allow his admission into the firm. Okay, so every partner has the right to stop the admission of a new partner, because trust factor is very important. But the important thing here is, in such cases, consent of all the partners is required. When one partner has to be admitted, consent of all the partners is required. Even if one partner is not agreeing, that new partner cannot be admitted. Okay, so consent of all partners is required for admission of a new partner. Next, right to retire. Every partner has the right to retire from the firm when he wants, when he thinks that possibly now he doesn't want to work in the firm, or his age is up, his time is up. or maybe any reason, for any reason, now he doesn't want to continue with the firm, he may retire from the firm. Now there are a couple of things with respect to retirement. The first thing is, he may give all the partners a notice of retirement, his a notice containing his willingness to retire, a notice showing his intent to retire, and then all the partners should agree to it. There should be consent of all the partners. Now let's say all the partners do not agree. There are 4 partners, out of which one partner wants to retire. 2 partners agree and one partner does not agree. The other 3 have to agree. So out of the 3, 2 agree, but one does not agree. Now what does he do? Does he have to stick with the firm for his life? No. The other option that he has is give a notice of dissolution. Dissolve the firm, then he'll no more be the partner. So this is the condition with respect to retirement. Next, right to be expelled, rather right not to be expelled. Every partner has a right not to be expelled. Of course, if you are not faithful to the firm, if you have committed frauds, if you have done some things wrong in the firm, then you may be expelled. But at the onset, if you ask me upfront, no partner has the right to retire, to be expelled from the firm. He does not have the right to be expelled from the firm. Expulsion is valid only if majority of the partners agree. Now this is very important. This question has been asked many times in exams. With regards to expulsion, what is required? Consent of majority partners, all the partners, one partner, or none partner. They give such options. So majority partners' consent is required. And in the partnership deed, in the agreement of partnership, this clause should be there that other partners have the right to expel one partner. A partner can be expelled. If no such clause is there in the partnership deed, in the agreement, then the partner cannot be expelled. Again, the option that remains is to dissolve the firm. So it is important that when the partnership is formed, all these things are listed down in the partnership deed, in the partnership agreement. If they miss out 1 or 2 clauses, that can be very dangerous. So like in this case, if a partner has committed fraud and the other partners want to expel him, but there is no clause of expulsion in the partnership deed, then they have no option but to dissolve the firm, and if they want, form another firm without that fraudulent partner. But that takes a long process. Again you have to do the documentation, you have to go through the winding up process, then starting a new firm again. That's very tiresome, that's tedious. Again you have to start with a new name, you have already built a name. So all these things make it very important that you include all these clauses in your firm. So majority of the partners' consent is required. It should be there in the agreement. Good faith. Now you should exercise the right to expulsion in good faith. Good faith, that means in the benefit of the firm. It should be in the benefit of the firm. It should be in the best interest of the firm, best interest of the partners. It should be in the greatest common advantage. Okay. And finally, as I said, it should be in the benefit of the firm. So if all these conditions are satisfied, a partner may be expelled. Otherwise, a partner has a right to not to be expelled. Next, right of outgoing partner to carry on competing business. Now, this is the right of outgoing partner, a partner which is retiring or he has been expelled, you know, either of the two. Either he is retiring or he has been expelled. Majorly, we should be concerned about retiring partner, because expulsion is not very common. Expulsion is not very frequent. So when we hear about outgoing partner, the first thing that should come to our mind is that the partner is retiring. Okay. Right of outgoing partner to carry on competing business, not in the firm name. However, the outgoing partner cannot be doing the competing business in the firm name. This competing business means business in the competition, in the same line. Let's say there was a firm with the partners HIJ. Okay, there were three partners, HIJ, and J retired from the firm. Okay, this firm was into the business of selling shoes. Now, since J has an experience of selling shoes, he retires and opens his own shop just opposite his firm's shop. Can he do that? Yes, he can do that, because he has a right to carry on any competing business. The condition is he cannot keep the name of his shop same as the name of the shop of the firm. Okay, whatever the name of the shop of his firm was, he cannot keep the same name for his shop. The name has to be different, and he cannot solicit the customers. Whatever the customers the firm had, he cannot call them in his own shop. He cannot solicit them. He cannot tell them, you come to my shop, I'll give you 5% discount, I'll give you this facility, that facility, etc. He cannot solicit them. So whatever the firm had clients, whatever clients the firm had, it takes a long time to build a clientele. So whatever clientele the firm had, he cannot solicit, he cannot advertise his shop to those clients. He cannot get those clients. And the last is, he cannot represent the firm. Now, since he is out of the firm, he cannot tell that yes, I am the partner of the firm, this is the second branch of the firm, so purchase from here. No, he cannot do business this way. He cannot tell the outsiders that he is still the partner, or this is the second branch of the firm that has opened and he is looking after it, he is representing the firm. So the outgoing partner has a right to carry on the competing business. Agreed. Competing business is the business in competition, the same business. However, he cannot do it in the firm name, he cannot represent the firm, and he cannot solicit firm's client. Next, right of outgoing partner to share subsequent profits. Option 2, have share of profit or interest at 6% per annum. Now, the outgoing partner has a right to share in the subsequent profits. This is only in that case where accounts have not been settled with outgoing partner. If the accounts with the outgoing partner have not been settled, that means his money is there in the firm. his money has not been repaid to him, his accounts have not been settled. So since his money is still there, though he's out of the firm now, his money is still there. So don't you think he should get an interest on it, or he should get a share in profits? Now it depends on him. He has the choice. If he wants to treat it as capital only, so he'll get a share in the firm's profit. If he wants to treat that money as a loan to the firm, so he'll get an interest at 6%. So the option lies with him. If his accounts are not settled, he has the option to get a share from the profits or get interest at 6% per annum. Next, right to dissolve the firm. Now, I told you a partner is the owner of the firm. He had started the firm. Since he had started the firm, he has the right to close down the firm also. He has the right to dissolve the firm. However, to dissolve the firm, consent of all the partners is required. However, if it is a partnership at will, then even one partner, by giving notice, can dissolve it. Okay.